All right, good afternoon, everybody. Thanks for logging on or watching. We're going to talk about a few forms today. We're going to talk about the inspection contingency addendum, financing addendum, seller's disclosures, as well as arbitration. So we're just going to dive right in. If you've got some hard copies, that's great. You can scribble some notes on the side. Otherwise, we'll just go ahead and cover some of the content here. So something to note about the inspection contingency, and this is big because they changed this last summer. It's kind of changed the way we've been approaching our inspections, so we'll have some good discussion and conversation about it. Let's dive right in. I'll tell you how I typically fill them out. Again, it's your business. You can fill it out however you want to or however your clients prefer, etc. But I'll just give you my standard way of practice. You can take that for what it is. So obviously, line one, we're going to put the date. We'll add the page number because it's likely going to be part of a PA, but that page number will be whatever it needs to be based on the kind of PA you're putting together. Line three, we'll put the date regarding the purchase agreement. Then lines 4 and 5 is going to be the actual property address. Now, when you look at lines 6 and 7, the purchase agreement is contingent upon any inspections of the property obtained by the buyer to determine the condition, including any non-intrusive testing or any intrusive testing as allowed pursuant to this purchase agreement. So the inspection addendum is absolutely crucial. It's a critical part of the buyer's initial offer on the property because this contingency allows them to, based on the results of the inspection or just based on anything during the inspection timeline, to be able to cancel the purchase agreement and receive their earnest money back. So this is a very, very important form. And that's kind of what lines 6 and 7 are saying. The purchase agreement is contingent upon these inspections. For the purpose of this form, intrusive testing shall mean any testing. Actually, excuse me, let me back up to line 8. Any inspections or tests shall be done by an inspector or tester of the buyer's choice. The buyer shall satisfy the buyer as to the qualifications of the inspector or tester. We've been some conversations about the fact that in Minnesota, to be a home inspector, you don't have to be licensed, right? So as far as the buyer is concerned, when they hire that person to come out and do the inspections or the tests, they themselves need to be satisfied with the person that they're hiring, okay? And they get to choose who it is they want to come out and do those inspections or tests. For the purpose of this form, intrusive testing shall mean any testing or inspections or investigations that change the property from its original condition or otherwise damage the property. Now, this is very, very important. Basically, we have to decide during our offer if the buyer wants to perform any intrusive testing or not. Again, intrusive testing is something that would change the physical aspects of the property, potentially damage it. And they're going to ask right here for the seller to agree or not agree to allow the buyer to perform intrusive testing, all right? In a standard transaction, in this market, a regular purchase, typically that box that's going to be checked on line 12 is does not, okay? However, let me give you some examples in which we might choose does. Let's say we're buying a distressed property, a foreclosed property, a property that's been abandoned. Maybe you have some concerns about mold, right? Well, in that case, the buyer might want to do some testing for mold, puncturing the drywall, for example, to do some moisture tests. And in that case, they'd have to ask the seller's permission to do that, and the seller could decide whether or not they want to allow the buyer to do that at the buyer's expense. And as we'll read on later, when we look to lines 13 and 14, if the answer is does, meaning if the seller does allow the buyer to perform intrusive testing, the buyer agrees that the property shall be returned to the same condition it was prior to the buyer's intrusive testing at the buyer's expense. By the way, I should mention questions are welcome at any time, so feel free. Yeah. So if we're going to go poking holes and testing for stuff, and the seller says it's okay, well, the buyer then needs to understand that we're going to go ahead and repair the property back to where it was at the buyer's expense.
So why would you usually check off does not agree?
Because typically in a normal home inspection, they don't conduct intrusive testing. Very, very good question. So like I mentioned, intrusive testing might occur when we want to punch holes in drywall to test for moisture. If we're going to be like removing siding or something to take a look at windows or things of that nature, that's above and beyond what's typically normal as a part of an inspection. So let's address another item, a radon test, not intrusive. And we can get permission for that. That's just a system that sits there. It takes readings for a couple of days and we're good.
How much radon do we have here in Rochester?
That's a great question. It's going to be hit or miss depending upon what property you decide to test. That's kind of the state in general. You could have one home be completely fine and under the magical threshold, and the next door neighbor could be over it. It's just kind of a goofy hit or miss. Okay, so we'll provide access to attics and crawl spaces. For the purposes of this addendum, calendar days shall end at 11:59 p.m. Sorry, that's a little hard to see up there. And include Saturdays, Sundays, and state and federal holidays. This is a big change. Those days used to be excluded, now they're included. All inspections, tests, and resulting negotiations, if any, shall be done within blank. You get to input the number of days that you want right here. We'll typically do about anywhere from 7 to 10. That gives you enough time to get somebody out there, do some of the negotiations. If you're going to err on the side of a good number, I'd maybe pick 10, right? You might get some pushback on the sellers from that. If it's a super competitive situation, meaning there's multiple offers, well, you might want to shorten it a little bit to show everybody that, hey, you're willing to move this along and you're not going to play any games. So it shall be done within blank calendar days of final acceptance date of the purchase agreement. The buyer may cancel this purchase agreement based on the inspection or test results by providing written notice to the seller or the seller's agent of the buyer's intent to cancel no later than the end, good morning or good afternoon, no later than the end of the inspection period. Now this next sentence I read is a huge differentiator between this inspection addendum and the previous one. If the buyer cancels a purchase agreement, okay, I spoke too soon. If the buyer cancels purchase agreement, seller and buyer will immediately sign a cancellation of the purchase agreement. Earnest money will be refunded. If the buyer does not cancel this purchase agreement, this is the important one. If the buyer does not cancel this purchase agreement before the end of the inspection period, then this contingency shall be deemed removed and this purchase agreement shall be in full force and effect. That's a big deal. It used to say, hey, if we don't reach an agreement by the end of this timeline, well, then we can have a canceled deal, right? But now it basically says, hey, buyers, if you don't kick us something or we don't come to an agreement by the end of this timeline, you're basically moving forward on the property. Big deal. And the way that we operate in my business and the way our team handles it is when you see the blanks, lines 29 through 33, we actually add some verbiage in there that says that buyers and sellers fail to reach an agreement, this purchase agreement to be automatically canceled. We basically override that sentence to provide the extra layer of safety to our buyers because worst case scenario, the buyers might submit something to the sellers, never hear back from them, and then, unless they say that we're going to cancel or withdraw the offer, and the sellers just refuse to respond, well, all of a sudden, based on the expiration of this timeline, they could be locked into a house, right? So we add that verbiage in there to give them that out in case we can't have that back and forth negotiation with the seller. Line 26, the seller or the seller's agent shall or shall not have the right to continue to offer the property for sale. Usually the box check there shall. Shall not can be checked sometimes. You use just shall. It stays on MLS. It just says an offer has been accepted contingent upon inspection. Not a big deal. And then, of course, you'd have folks sign at the bottom of it. Any questions on that one? Very good. So let's move on to conventional mortgage financing addendum. Conventional financing is becoming more and more common just because people are needing to be more competitive. And now there are programs out there that have a minimum down payment of 3%, which is making it more available to folks. So again, line 1 is the date. Line 2 is the actual date of the purchase agreement that the addendum pertains to. It could be the same date, could be two different dates, depends on when paperwork was filled out. Property address on lines 4 and 5. Line 6, financing will be usually, you're checking the first box, first mortgage only, and they shall apply for and secure at buyer's expense. Usually, the box at number 8 is checked, conventional, okay? Sometimes, right now, especially in our area where we have a lot of rural areas surrounding us, you might see that the USDA financing option is checked as well. But it's important to know and filter away and make note that a USDA loan, that type of financing is actually in fact conventional, even though it's a 0% down program, okay? Highly recommend if you've got clients that are considering that and using it, talk with their lender about it. Make sure you've got a good understanding. Make sure the clients have a good understanding of that program. It's a 0% down program, but it's only allowed in certain areas. That's where you need the lender to come into play to tell you if it's going to be allowed to be utilized on a certain property or not. Understand that it's 0% down if they choose to put 0% down. And general rule of thumb is that USDA loans might take a little bit longer than average to close. So you might want to budget maybe 2 to 2.5 months versus a month and a half to 2. And that might vary depending upon the time of year. So the takeaway from lines 8 through 12 is you're usually almost always, if you're going to use conventional financing, check line number 8. Otherwise, you might be checking line number 10. Any of the others in there are pretty rare or on a case-by-case basis. If you find yourself in that situation and you already know what to do, great. If not, just find me or Bruce or somebody else in the office that's a seasoned agent that can walk you through that one. Or better yet, ask the lender, hey, which box should I check based on the financing this person intends to utilize? Yes, ma'am.
Wouldn't line number 9 be used more? That's when you have PMI.
It depends. Usually you just go with conventional. Then it's going to come ask down here how many years and what's your percentage.
Okay, but if you only put down 5%, it's insured.
I'm telling you, most often you're going to go box 8. Yep. So line 13, it's going to be a first mortgage amortized over a monthly period of no more than almost always 30 years. You might have that person every once in a while that pops up at 15, almost always 30. Line 14 at no more than blank percentage. I usually put market rate. That's what I usually put in there because the rate's kind of always fluctuating. You're going to hear people give you different opinions on that. I put market rate because it covers our bases. The mortgage application is to be made within 5 business days after the final acceptance of this purchase agreement, if it already hasn't been started. Buyer agrees to use best efforts to secure a commitment for such financing and to execute all documents required to consummate said financing. Line 18, seller's contributions to closing costs. So your buyer has the ability to either ask or not ask for the seller to contribute to their closing costs. Right now, it's really dependent upon what sort of offer they're presenting, because if it's a multiple offer situation, etc., they might not ask for any. Maybe they do ask for it and they roll it on top, whatever. Usually we're checking is. We're usually asking the seller to pay some sort of the buyer's closing costs. Okay, but when you check is, know that also triggers another form that you're going to need called the seller's contribution to buyer's closing costs form. Okay, but if you check is not, then you don't need that form. So this right here is really an indication to the listing agent that they need to look for that other form, because on this one we're saying we're asking for closing costs, but we're not saying how much. On the other form, we'll identify exactly how much we're asking for. Line 20, financing contingency. This purchase agreement is contingent upon the following and applies to the first mortgage and any subordinate financing. Okay, so your buyer has a couple of options here. Let's look at the 2 options and then we'll have a discussion about them. Line 22. If buyer cannot secure the financing specified in this purchase agreement, and the purchase agreement does not close on the specified closing date, then this purchase agreement is canceled. Buyer and seller shall immediately sign a cancellation of purchase agreement, directing all earnest money paid to either refunded to the buyer or forfeited to the seller. Now, if you represent the buyer, you're always going to want to check refunded to the buyer, right? All right, let's look at line 26 now. Buyer shall provide seller or the seller's agent with a written statement on blank date. This date I usually personally pick either about a week or a week and a half prior to closing. That usually gives your lender enough time to produce this written statement. And it's well out enough from closing to give everybody a warm and fuzzy that we're looking good. So the buyer shall provide the seller, or really the buyer's lender, or even the buyer's agent, shall provide the seller a written statement on or before insert date, usually a week to week and a half prior to before closing. For the purposes of this contingency, a written statement means a written statement prepared by buyer's mortgage originator or lender after the acceptance date that the buyer is approved for the loan specified in this purchase agreement, including both the first mortgage and any subordinate financing, if any, and stating that an appraisal satisfactory to the lender has been completed and stating conditions required by the lender to close the loan. All right, so this is not a pre-approval. This is, we've got a written statement from the lender basically saying, we've been through the appraisal, we've done everything we need to on our end, it looks good, we should be good to close. That's what the written statement means. Upon delivery of the written statement to the seller or the seller's agent, the obligation for satisfying all conditions required by the mortgage originator or lender, except those conditions specified below, are deemed accepted by the buyer. Work orders that need to be completed by the seller, any other financing terms agreed to be completed by the seller, and any contingency for the sale and closing of buyer's property pursuant to this purchase agreement. Okay, we're basically saying, hey, once we get you this written commitment letter, we're good. We're closing on this thing, right? Now we all know anything can happen, but that's the purpose of the written commitment letter. Upon delivery of the written statement, if this purchase agreement does not close, this is a big differentiator. If it does not close on the stated closing date for any reason relating to financing, including but not limited to interest rate and discount points, if any, then the seller may, at seller's option, declare this purchase agreement canceled, in which case this purchase agreement is canceled. If the seller declares it canceled, the buyer and the seller shall immediately sign a cancellation of purchase agreement, confirming said cancellation and directing all earnest money here to be forfeited to the seller as liquidated damages. In the alternative, the seller may seek all other remedies allowed by law. So
up above where you check off refunded to the buyer, does that supersede this one?
great question. You would choose either the option for the box on line 22 or the box on line 26. So you're only picking one or the other. So if you go to the box for line 22, then you're checking either refunded or forfeited, and you're skipping 26 and all that stuff. Okay. But if you go with 26, then you don't have that option. And 26 is very powerful, and this is really what sellers want to see. It's pretty common practice to see that box checked with a commitment letter date in there, because the buyer is saying to the seller, we're going to get you a commitment letter, or rather our lender is going to get you that commitment letter by this certain date, and if they don't do that, or if they get it to you and we still fail to close, at that point in time, our earnest money is forfeited to the seller, in theory, because everything's negotiable. Okay? So that one gives the seller a little bit more of a warm and fuzzy, and it holds the lender accountable to get their work done before closing. Any other questions on that? Okay. Next page, line 46, property address goes in there. Line 47, notwithstanding the language in the preceding paragraph, the seller may not declare this purchase agreement canceled if the reason the purchase agreement does not close was due to, basically, if it was the seller's fault. Seller's failure to complete work orders, seller's failure to complete any other financing terms agreed upon, any contingency for the sale and closing of a buyer's property pursuant to this purchase agreement, except as specified in the contingency for the sale and closing of buyer's property. Okay, because sometimes people's financing is dependent upon them closing on a previous property. This is kind of giving them a little bit of protection. If for some reason that closing falls through and it affects this one, let's kind of give it some verbiage that would maybe protect the buyer in that case. If the written statement is not provided, this is also important. If the written statement is not provided by the date specified on line 27, the seller may, at the seller's option, declare this purchase agreement canceled. In which case the buyer is notified and they will both sign a cancellation. In the event the seller declares this purchase agreement canceled, they'll sign it and all earnest money will be refunded to the buyer. Okay, so if the seller just says, hey, you missed your date, we're canceling, well, the earnest money goes back to the buyer, right? But if we get past that date, they've received the letter from the lender and we're like a day or two before closing, and the buyers just get cold feet,
Right.
well, at that point, if they do cancel, the seller gets to keep their earnest money. And honestly, that's going to be the least of the buyer's problems or worries, because the seller can do a lot more at that point as well. 62, private mortgage insurance, or PMI. PMI may be required by the lending institution. Buyer agrees to pay all subsequent years' mortgage insurance premiums as required by the lender. The said mortgage insurance premiums will increase the mortgage amount unless paid in cash at closing. Locking of the interest rate. Hey, do we want to lock it? Do we want to have them lock it in within 5 business days of this purchase agreement being accepted, or are we going to let them ride out the rate and they can close it in at any time prior to closing? Usually, the box in line 68 is what they check right there. Gives the buyer some flexibility regarding their interest rate. They can choose to lock it in right away, or they can wait till closer to closing. I always recommend buyers continue to stay in communication with their lender about that and seek their lender's recommendation. Line 69, lender commitment work orders. Nothing in this purchase agreement shall be construed as a warranty that the seller shall make repairs required by the lender. However, a seller agrees to pay up to blank, you can insert an amount right there, to make repairs as required by the lender commitment. If the lender commitment is subject to any work orders for which the cost of making said repairs shall exceed this amount, the seller shall have the following options: make the repairs, negotiate the cost of making the repairs, or declare the purchase agreement canceled, in which case they can cancel it, they'll sign a cancellation. All earnest money will be refunded to the buyer unless buyer provides for payment of the cost of said repairs or escrow amounts. Okay, so let me explain this one. Work order repairs, basically this relates to the appraisal. If an appraiser comes out there and says, hey, we've got an issue, we've got some chipped peeling paint, or we've got a deck that needs a railing, I'm gonna attach a work order to this appraisal and say this work needs to be done prior to closing, right? So what a buyer could potentially do when they're negotiating and making their initial offer is say, hey, Mr. and Mrs. Seller, if there are any work orders, we're already gonna ask you to agree to pay up to $200, $300, $500 toward any work orders that arrive as a result of the appraisal, okay? And then that kind of gives you some scenarios of what would happen if it's above and beyond that, etc. But here's the deal, and this is how I explain it to buyers. Basically, what we're doing here is we're negotiating money that we think we maybe need, right? If the seller is going to agree to a $500 amount, I would rather just take that off the price overall to begin with, instead of potentially leaving money on the table. Because guess what? If they agree to $500, but no work orders come back, well, that was $500 that just got left on the table that the seller was willing to spend, right? So I will typically put a 0 there, and because of my experience, I know if a work order does come up, we can almost usually get the seller to pay for it anyway, or it becomes negotiable at that time, right? So just something to file away. Now, it might make sense to put some numbers there if you know for sure something is likely to get flagged. Okay, well, now we might want to try to preempt that a little bit by putting the amount in there. We might explain why we're doing that when we present the offer. Hey, you're going to see $500 in there. It's because we noticed this issue. We just want to make sure that the seller will take care of it if and when that gets flagged on the appraisal. If you have a question, maybe. No? Okay. So the takeaway from that is you can insert an amount if you want to. Me personally, I typically throw a 0 in there, and if something does happen, if there's a work order that comes about, we'll usually negotiate it at that time. The seller or the buyer agrees to pay any reinspection fee required by the buyer's lender. So in exchange for me putting a 0 there and the seller having to do any potential work orders, if we negotiate it, I'll usually check the buyer box on line 80 saying, hey, if there is a work order that comes about, the seller, hopefully we can get them to take care of it, and in exchange for that, the buyer will pay the reinspection fee to have the lender come, or to have the appraiser come back out there and check it out. But again, that's just kind of how I do it. You and your buyer are free to do whatever you think makes the most sense. Then, of course, we'd have them sign at the bottom there. Any questions on that one? Very good. Okay, so we did the conventional financing addendum, which covered conventional financing and USDA. Now we're going to switch to the FHA financing addendum. We put the day's date, the date of the purchase agreement, the property address. Then we're going to look at line 6. Buyer shall apply for and secure at buyer's expense A. Usually line 7, check FHA loan, right? It's usually almost always going to be fixed. It's very likely not going to be an ARM, so you would write fixed in that blank right there. The mortgage and the amount stated in this purchase agreement amortized over a monthly period of no more than, usually 30 years, with the initial mortgage interest rate at no more than market rate. The mortgage application is to be made within 5 business days after the final acceptance of this purchase agreement. Buyer agrees to use best efforts to secure a commitment for acceptance for such financing and to execute all documents required to consummate said financing. Again, the same question, are we asking the seller to or not to contribute to buyer's closing costs? If it is, see the form, purchase agreement, seller's contribution to buyer's costs. Financing contingency. This purchase agreement is contingent upon the following and applies to the first mortgage and any subordinate financing. Box 1, box 2, it's the same exact thing. They've got the same options. Do we want to provide a commitment letter or not? Same discussion from the last financing addendum. Property located at, the address goes there. We'll come down to mortgage insurance premiums. Pursuant to federal regulation, a one-time MIP must be paid to FHA at closing of this transaction. The said MIP will increase the mortgage amount unless paid in cash at closing. This provision may not be applicable to condominium transactions. Now this is big, and you might have to talk to the lenders about this. But it used to be your mortgage insurance premium, you could potentially get that dropped from the loan if it was FHA once you had at least 20% equity in the property. But now it sticks for life of the loan. Yep. So, but that would maybe be a good discussion point with the actual lender, or you could just have a conversation with the buyer about that, and maybe when they get closer to that 20% threshold, they refinance. Maybe they switch to conventional financing at that point in time, which might allow them to drop that.
Did that just change the last couple of months?
Last couple of years probably. And so, but there are plenty of people out there that still have the old FHA loans. I actually just got a notice in the mail myself that said, hey, we're going to be removing the extra MIP because you hit that threshold. But that being said, if people are using those now moving forward, it's there for the life of the loan. So it's also another reason why I think we've probably seen a little bit more conventional stuff. Locking in on the interest rate, again, they have the same option within 5 days, or do we write it out? FHA work orders, the same thing as the work orders for conventional. And here's going to be an interesting, same thing, who's going to pay for the reinspection? Usually we're checking buyer, in my instance. Lender processing fees. Seller agrees to pay miscellaneous processing fees, which the lender cannot charge to the buyer, not to exceed blank. This amount is in addition to seller's contributions to closing costs. Okay, I usually put a 0 here, right? Because I'm going to go after the closing costs, right? And I'm going after the price. Those are the two things I'm working. So I'm usually putting a 0. Maybe if you talk to the lender or the title company, they might have a recommended amount you can put there potentially. But usually I'm just going to ask for an amount in closing costs that's going to get everything covered, right? Okay. Now this one's important, and it's important to probably put a star next to or make note of, because this FHA escape clause does not exist on the conventional financing addendum. However, what the practice that I do is I take this escape clause and I essentially add it to the conventional financing form. And I'll explain to you why and how that works. This escape clause also exists on VA financing forms as well, which we're not going to be going over today, but VA is relatively similar to FHA. It is expressly agreed that, notwithstanding any other provisions of this contract, the purchaser shall not be obligated. The purchaser is synonymous with the buyer. The buyer shall not be obligated to complete the purchase of the property described here, or to incur any penalty by forfeiture of earnest money or otherwise, unless the purchaser has been given, in accordance with HUD, FHA, or DVA requirements, a written statement by the Federal Housing Commissioner, Department of Veterans Affairs, or a direct endorsement letter setting forth the appraised value of the property at not less than blank. Okay, so where that blank is, whatever price you are offering, that same number is going to go right there. That's the sale price, right? So basically what this is saying in a nutshell is, hey, if this home does not appraise for the contract sale price or greater, the buyer can cancel this agreement and get their earnest money back. It's a big deal, because guess where it does not exist? I mentioned it before. This does not exist in the conventional financing. Okay, but what you can do is you can add it to it. So the verbiage that I would typically add to the conventional financing addendum sounds like: buyer reserves the right to cancel or renegotiate the contract if the property fails to appraise for the contract sale price or greater, and have their earnest money refunded to them. Just pausing for a minute for folks to take some notes. Any questions on that? Okay, it's a big deal. You can do well by your clients and really show them some added value if you take verbiage like that and you add it to that conventional financing addendum. It's very similar to adding the verbiage to the inspection contingency, where we say, hey, here's the deal. I know what this says regarding that timeline, but I'm going to add this verbiage that supersedes that. It says if we hit that expiration, the buyer has the right to cancel. The seller just doesn't automatically think that they have us locked in, right? Line 84, the buyer shall have the privilege and option of proceeding with the contract without regard to the amount of the appraised value. The appraised valuation is arrived at to determine the maximum mortgage amount that HUD and all those guys will warrant and guarantee. The buyer should satisfy him or herself to that price and condition of the property. So basically what this is saying is, hey, if we have an appraisal come back $5,000 short, it's not automatically canceled. The buyer does have the right, if they want to to either close the gap on that, maybe we renegotiate, etc. Okay, so hey, if we have an appraisal issue, it's not automatically canceled. However, if the buyer, just can't make it happen, well, then it can be canceled, and the buyer will get their earnest money back. That's the biggest piece of it. The buyer is allowed to get their earnest money back. Now, conventional loans, if it doesn't come back at the appraised value, and we didn't add that other verbiage, technically, in theory, the sellers could maybe still force the buyers to move forward with purchasing that home if they have the money to do so still. Last portion of the form, we're going to add the page number, the property address, and here would be a place where we could add some additional verbiage if we needed to. Again, we don't quite need it on the FHA one, but this is on the conventional one where we would add that additional verbiage, and they would sign toward the bottom. Okay, so let's transition to the seller's property disclosure statement. This is not the alternatives. This is the normal one that you traditionally use about 99% of the time. I'm going to put the date on there. And it's really important that when we're working with sellers, we help them realize and understand the importance of the seller's disclosure. And when in doubt, disclose. When in doubt, disclose. Okay, it's just honesty and safety is the best policy. If you think you know something, disclose it. But what we can help them do is word it in a way that doesn't necessarily cause people to be over alarmed if there's no need to be. Okay. So let's dive right in here. This information, the information disclosed is given to the best of the seller's knowledge. There's plenty of things that might be going on with their home that they don't necessarily know about, right? You can't see behind walls, okay? Notice this disclosure statement satisfies the disclosure requirements of state law with limited exceptions listed on page 9. Sellers are obligated to disclose to prospective buyers all material facts of which seller is aware that could adversely and significantly affect an ordinary buyer's use or enjoyment of the property. So material facts are things that would affect a buyer's use or enjoyment of the property, or any intended use of the property of which the seller is aware. State law requires the seller to notify the buyer in writing as soon as reasonably possible if in any event before closing, the seller learns that the disclosure was inaccurate. Let me give you an example of this. Carly, my wife, so we're just meeting for the first time. I'll give you a little bit of background. My wife and I, Carly, we run a real estate team up in the cities, and she pretty much runs the team now since I'm down here, training and helping with the office. So she had a listing over last weekend where we were the listing agents, and it was listed. We got an offer. Offer was accepted. We were through inspection, and we had a lot of rain recently, right? So Jared, our client, the owner, seller, calls Carly and says, hey, we got a little water in the basement. I'm just calling to let you know. Like, okay, here's the deal. Have you had somebody out there to see what the issue is? What can we do about it? What sort of repairs can we make to prevent it from happening again? Oh, by the way, we're going to have to update the disclosures and let the buyers know right away, right? Because one of two options could go down here, right? We could either just be quiet about it. He could have just been quiet about it, not even let us know, which would have been a failure to disclose, right? But in this instance, when we write these seller's disclosures, there's a lot of stuff that can happen between writing these, selling the property, having the inspection, having the appraisal, and actually closing on it, right? So if anything major happens that would affect the disclosures, we have to redisclose and update these documents even during that pending period. So it's very, very important, relevant information. So what we did is how we approached it is we said, okay, Jared, first let us know, how significant it is, where is it, get a contractor out there, evaluate it, and let us know what you guys plan to do to alleviate this problem. He had all that information, we gathered it, we took it to the buyers and said, hey, we want to let you know this is what happened. They've identified the issue, and this is what the seller's doing to fix it. No problems. They said, okay, sounds good, thanks for letting us know. We update the disclosures, okay? So that was a big difference on how we approached it, because we could have just said, oh my God, buyers, we've got water in the basement, and just left it at that. Well, how do you think the buyers would have responded? Holy crap, we're out of here, peace, we're done. No, instead of just saying, we've got water, I said, here's the deal. They had a little bit of water. We know why. We know what they're going to do about it. They plan to do it. It'll be done by this date. And oh, by the way, if you guys want to come out and take a peek, you're more than welcome to, right? Full disclosure. Err on the side of disclosure. Okay, where are we at here? Mission enjoyment. Okay, line 14. Seller has disclosure alternatives allowed by state law. For further information regarding disclosure alternatives, this disclosure is not a warranty or a guarantee of any kind by the seller or the seller's agent, and is not substitute for any inspection or warranties the parties may wish to obtain. Okay, we're basically saying, if I give you a set of seller's disclosures that says, hey, the house is in good shape, I'm not aware of any issues with it, you close on it, and 2 weeks later you have an issue, doesn't mean you can come back after me. Someone say, hey man, I didn't know. Either that's bad luck, or it's bad timing, or it was something going on that I didn't know about, therefore I didn't disclose it, right? Because stuff happens, right? Buying a used home, it's just like buying a used car. There's gonna be maintenance involved and stuff breaks down on occasion, right? For the purposes of seller disclosure requirements regarding state law, residential real property or residential real estate means property occupied as or intended to be occupied as a single family residence, including common interest communities or condos, etc. The seller disclosure requirements of state law apply to the transfer of any interest in real estate, residential real estate, whether by sale, exchange, deed, contract for deed, lease with option to purchase, or any other option. We have to have some form of disclosure occurring when we're transferring property or when there's the intent to transfer property. Instructions to buyers. Buyers are encouraged to thoroughly inspect the property personally or have it inspected by a third party. I would say personally and have it inspected by a third party, and to inquire about any specific areas of concern. Note, if the seller answers no to any of the questions listed below, it does not necessarily mean that it does not exist on the property, did not occur, or does not apply. No may mean that the seller is unaware, right? Because how many people may have owned this property in the history of its existence, right? They might be the 5th owners, right? So they've owned it. The people before them maybe had water in the basement, didn't disclose it to these people. Since they've lived there, they've never had water in the basement. And the disclosures asked, have there ever been water in the basement? Well, they're going to say no, because to the best of their knowledge, there never has been, if they were ever informed about it before, right? It doesn't necessarily mean it's never happened. Also, what's a very common one is people will get asked, hey, do you have a well on your property? And they'll say, no, but in fact they do. It's just not in use and it's sealed, right? They didn't even know about it, right? So it doesn't mean there's not a well there. It just might mean they don't know about it. Instructions to seller. Complete the form yourself. Complete the form yourself, meaning the agent probably shouldn't be the one completing it. Consult prior disclosure statements if you have them and or inspection reports. I have my seller's disclosures for the people I bought the home from, so if you have those, great. A lot of people don't, a lot of people do. Describe conditions affecting the property to the best of your knowledge. Attach additional pages with your signature if additional space is required. Answer all questions. If any items do not apply, write NA, meaning not applicable. Okay, so property address, city, county, general information. What date did you acquire or build the home? Do you have an abstract? Is it registered towards? Do you not know? Typically in Minnesota, it's going to be one of the two. Okay, if it's a more recently built home, newer, it's probably going to be registered towards. Or if it has sold recently, it's probably going to be registered towards. Otherwise, it's going to be an abstract. They may or may not know the location of their abstract. They're going to ask if there's an existing owner's title insurance policy. Have you occupied this home continuously during your ownership? Is it suitable for year-round use? Are you in possession of the prior seller's disclosures? Does the property include a manufactured home? So these are all yes or no questions for them. So the top of every page, you're going to put the property address again. Is it located on a private or public road? Flood insurance? Do you have flood insurance? If you do, what do you know about it? Are you in a zone? What zone? Blah, 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 things of that nature. Line 62, whether or not a seller currently carries flood insurance, it may be required in the future. Flood insurance premiums are increasing and in some cases will rise by a substantial amount over the premiums previously charged for flood insurance for the property. As a result, the buyer should not rely on the premiums paid for flood insurance on this property previously as an indication of premiums that will apply after a buyer completes his purchase. Basically, this is saying, hey, use some common sense and get some flood insurance quotes before you close on this property so you know what you're actually getting into. Don't just rely on what the seller currently has or has had in the past. Are there any encroachments, associations, covenants, etc.? Are there any governmental requirements or restrictions that might affect the use or enjoyment of the property? Are there any easements other than utility or drainage easements, because those are typically common? Please provide clarification or explanation for any of the boxes checked yes above. General condition, to your knowledge, have any of the following previously existed or do they currently exist on the property? Has there been damage by wind, fire, flood, hail? Do you think it's fairly common to see a yes to that? Absolutely. Absolutely, right? Wind can tear siding off. Hail can cause damage to roof, windows, sidings, etc. So it could be fairly common to say, yes, hey, we had hail damage in 2006. Oh, by the way, what's the next question? Have you ever had insurance claim against your homeowner insurance? Yes, for hail damage in 2006, right? You'll likely see some of these coincide, or people would just say, yeah, we had this incident, and this is what we did about it, or this is what happened. Did you receive compensation for the claim? And did you repair the item, or did you just use it to buy a sweet motorcycle, right? What dates did the claim occur? So this is also a takeaway from this is if you're going to go on a listing appointment or you're going to be meeting with some sellers, you can either send them this ahead of time or say, hey, here are a series of questions that we're going to need the answers to in our meeting. So if you can have some of this prepared or with you, that'll make our meeting go much more quickly, save you some time. Again, property address. Has the structure been altered? Has there been an addition? Have you altered roof lines for any reason? Have there been any changes to the load-bearing walls? Right? Have you done any remodeling or anything significantly to the structure? Has any work been performed on the property? Again, additions, wiring, electrical work, plumbing, things of that nature. Are you aware of any work performed on the property for which appropriate permits were not obtained? This is a huge one. And how often do you, of all the potential issues, there might be a handful of ones that people kind of blur the lines on. This is going to be one of them. Were permits pulled for that deck? How about that basement you finished? You know what I mean? Did you pull permits for that?
So if permits weren't pulled, then you have to get it permitted before you can sell it?
Not necessarily. It might depend on what city you're in, right? But what you might do is if you walk downstairs and you see what appears to be a newer basement, you might choose to call the city and say, hey, do you have any permits on file for the work that was done in the basement? If they say no, well then what do you now know? They didn't pull permits for the work, which means who knows who did it and if it's code, right? But you don't necessarily have to get the permits completed to close on the property. It could be just a risk the buyer decides to assume. Otherwise, another story that Carly's working through right now is we've got a client who their previous agent helped them purchase the property and they didn't catch the permits weren't pulled for a kitchen remodel. And now that we're selling it, the city of St. Louis Park requires somebody to come out there and examine the property. They came out and said, hey, we're looking at everything, and oh, by the way, the permits were not pulled for the work done in the kitchen. So guess what he now has to do? The city of St. Louis Park requires that get closed out before it transfers again and closes. Some cities don't. So you have to also know what city you're operating in. Has there been any damage to the flooring or flooring covering? Do you have or have you previously had any pets? Foundation. This type of foundation is block, poured, wood, stone, etc. That's going to be disclosed here. Very, very important. So I also teach pre-licensing. So I teach people what the different types of foundations are, and I teach wood all the time. I say, you know, it's not very common. You're typically not going to see it here in Minnesota. It was something that was used in the past. It's just really not. I've never seen one ever. And guess what? Carly just took some clients through a property and has a wood foundation. It's like, oh Lord, and they want to make them out. Like, oh man, let's see what happens, right? But we're asking, what kind of foundation do you have? Basement, crawl space, slab, etc. Are there any cracks or such in the walls? Okay, if you have an unfinished basement and it asks you if there's any cracks in the floors or the walls, what will the answer likely be?
Yes.
Yes, right? Settling cracks, it happens, right? So, you know, we just have to help explain to sellers what that really means. Any drain tile problems, again, that you know of, right? When's the last time somebody actively examined their drain tile, right? That's buried. You can't necessarily see it, right? So maybe, to the best of my knowledge, I don't know of any drain tile problem. Doesn't mean one doesn't exist, right? You ever had any flooding, foundation problems, leakage, or seepage, right? Well, we check no with our previous sellers I was telling you about. Well, now we have to come back and update that. Well, yeah, now we do know about something that just happened. Any sewer backups, wet floors or walls, etc. If yes, please explain. Now, here's what I tell people, because it's fairly common, you know, here in Minnesota, especially if the home is a little bit older, that you may have experienced a little bit of leakage or seepage in your basement, right? The question is, what did you do about it? Did you fix it? And have you had any issues since? So if somebody says, yeah, hey, Zach, back in 2005, we had some water in the basement. I'll say, great, what did you do about it? We added gutters. We put a downspout there. Cool, has it happened again? No. That's exactly what I want you to write. We had some, water come in the northwest corner of the basement, added gutters, no problem since. Because what that's telling buyers is, yes, we're disclosing the issue, but this is what we did about it, and we have not had a problem since, right? Roof. What's the age of the roof material? Do you think everybody knows how old the roof is? Absolutely not. I've seen so many different ways that this question has been answered. Some people will put unknown. Some people will put 5 to 10 years. Some people will put approximately 15, right? So whatever their best guesstimate can be as to the age of the roof, they should put that in. But if it is a guess or an estimate, they should denote that. Because there's a difference between 15 years and approximately 15 years, right? A detached garage. All right, is it sometimes common that maybe we re-roof the home, but we didn't touch the garage? We needed to note that and distinguish, okay, because a lot of times if we say age of the roof 15 years, people are going to automatically assume the same is true of the garage. Might not be the case. Let's distinguish that. Has there been any interior or exterior damage? Have there been any damage from ice buildup? Have there been ice dams? It's not asking you, has there been an ice dam? It's saying, has there been any damage from an ice dam or an ice buildup? Any leakage? Have there been any repairs or replacements made to the roof? Yes or no? Give any details to yeses. Property address gets added again. Exterior and interior walls, siding and windows. Hey, what type of siding do we have? Are there any cracks or damage? Any leakage or seepage? Other? If yes, give an example. A common one I see is I'll go out on somebody's deck, I'll turn around and I'll look at the home, and it might not be there, but I can sometimes tell where they have put the grill. Why do I say that? Because what does the siding look like? It's warped, right? Because that grill got so hot, it warped the siding a little bit. So hey, if that's something we need to disclose, yeah, we've got a little bit of warped siding where we used to have the grill on the deck. It is what it is. Just because they're disclosing this stuff doesn't mean they have to do anything about it necessarily, right? Appliances, heating, plumbing, electrical, and other mechanical systems. This section refers only to the working condition of the following items. Answers apply to all such items unless otherwise noted in the comments below. Personal property is included in the sale only if specifically referenced in the purchase agreement, okay? So let's go through this fun one. An important distinguishment. Check NA for only those items not physically located on the property. So you've got three options. You've got yes, it's in working order, no, it's not in working order, or NA, it's not on the property, meaning we don't have it, right? Sometimes what people will do is they'll check NA, meaning not in working order, or they'll check no, we don't have one, and people get confused. Well, do you have one, or you just tell me it doesn't work, or what's going on here, right? So we'll go through the list of stuff. Air conditioning, what type, air exchange, detectors, ceiling fans, all this fun stuff. I just usually tell people, hey, if there's something that you don't have, just put a line through it. I mean, clearly, no, we don't even have that, right? And there's a lot of stuff on here that they likely will not have. Hopefully, they have toilet mechanisms support.
Hopefully, they have what mechanism?
Toilet mechanisms.
Oh, okay.
Yeah. So let's use the lawn sprinkler system for an example, right? If we check yes to this, we're not saying yes, we have one. What are we saying?
Yes, it works.
Yes, we have one and it's in working order. Because if I check no, what am I saying?
Doesn't work.
I'm saying yes, we have one, but it's not in working order. And if I check NA, what am I saying?
Don't have one.
We don't even have one. Good, good. That's the most important distinction right there.
Do you ever have people ask you what the electrical system is?
Oh yeah. Hey, yeah.
I just assume it's electrical.
Right.
Like
electrical
wiring.
wiring, your breaker box and all that jazz. Yeah.
So what's
Yeah.
a drain tile system?
Great question. So drain tile is, hey Debbie, how are
Can I come in
you?
and join you?
Absolutely, please do. Thank you. Drain tile is, it's a modern day way to help people keep water out of their basement. Yeah, here's what I'll do. Once we finish this course and I shut off the recording, I'll pull up a picture, I'll draw what drain tile looks like and everything it does. Good question. Next page, we're gonna add the property address. Are there any items or systems, that smells delicious by the way, on the property connected or controlled wirelessly via internet protocol, IP, to a router or gateway or directly to the cloud? Now this was new. I spent some time on the forums committee a couple years ago and we specifically discussed this and I thought it was kind of interesting. But they're basically asking, hey, is there anything on here that, you know, it has a wireless connection to something that we should basically know about, right? Because we want to make sure that we shut those off or that you no longer have wireless connection to them once you're out of the home, right? Because now it's our property. I don't want you creeping on me anymore, right? Subsurface sewage treatment system. That's a fancy name for a what kind of system? A septic, perfect. A subsurface sewage treatment system disclosure is required by state law. Okay, so if there is a well or a septic, which we'll talk about next, that requires an additional disclosure in addition to this one, the seller certifies that they do or do not know of a septic in the property, either on or serving, right? It doesn't have to be in use. If we've got one that's no longer in use and it's buried on the property, but we know about it, we still have to disclose it, right? Serving the above described real property. If the answer is does and the system does not require a state permit, see the disclosure. That's a different disclosure. Okay, or there's an abandoned subsurface sewage system on the above real estate property, which we still have to disclose and its location, right? Private well disclosure, very similar. The seller certifies that they do not know of any wells on the property or that there are one or more wells on the property. No, it has nothing to do if they're in service, if they're working, if they're sealed. Nothing to do with that. You either know of it or you don't. I don't care what the status is. Me, for example, we've got a well that's capped and sealed in our property, but I know of it, so I have to disclose that we have one, even though it's got nothing to do with my property. I don't even ever think about it, but I have to disclose it. A great source you can go to for wells is the Minnesota Department of Health. Every well should have an ID number. The state tracks whether or not they've been sealed or capped, when and who by. So if you contact the Minnesota Department of Health, they can help shed some light and point you in the direction of that information. Are there any wells serving the above described property not located on the property? That could certainly happen. Or maybe there's a shared well. My property boundary line might stop here, but there's a well just on the other side of it that serves my property. Well, we need to disclose that and have a conversation about, oh, by the way, how many properties does this well serve? Property tax treatment, valuation exclusion disclosures. There is or is not an exclusion for market value for home improvements on this property. Any valuation exclusion shall terminate upon sale of the property, and the property's estimated market value for property tax purposes shall increase. If a valuation exclusion exists, buyers are encouraged to look into the resulting tax consequences. Now, let me give you an example, right? And I'm going to use the example of like a disabled veteran. Okay, let's say we've got an older Vietnam or Korean War veteran. They went overseas. They got wounded. They've got some physical disabilities as a result of their service. Well, the county that they live in or the city that they live in might give their property a value exclusion to keep their property taxes lower because they're thanking them for their service. So in the real market, the market value or the taxable value might be $250,000, but because of this person's service and what they went through, they have a program that says, hey, we're going to arbitrarily say that your market value is $150 because that's what we're going to base your taxes on to save you property taxes. But guess what? The buyer of that property needs to know that because they're not going to get the same exclusion when they buy it, right? So their property taxes might jump through the roof based on what they currently are. So if they close on the property, didn't know that, and they see their taxes go up by $1,000 a year, that might be a huge, huge issue, right? So we didn't know about it ahead of time. And the buyer needs to do some research to find out, okay, if there's a value exclusion right now, what's the actual market value likely going to be? meaning what are my true taxes going to be once the property becomes mine? Very rarely do you ever run into this situation, and your title company should also be helping you with this as well. But usually your title company is not involved until you've already come to terms and you're working on closing on the property, right? So you want to look into that.
However, if you're working on the veteran, you can just call county.
Absolutely. Well, I always recommend when you're helping a buyer purchase a property, call the city, call the county, just ask questions about it. What permits were pulled, when, are the taxes up to date? Are there any special assessments, any pending assessments, any levied assessments? Just ask all those questions. Preferential property tax treatment, this is kind of related to that. Is a property subject to any preferential property taxes, tax status, or any other credits affecting the property? Disability, green acres, there's a bunch of them. There are some people out there that just have land that's treated or taxed differently because they don't want it developed. And so because they don't want it developed and disturbed, they actually get a little bit of a tax benefit to it. We just need to know about that so that everybody is aware of it. Then I would probably ask some questions about it if I represent the buyer to say, hey, could this potentially change if we become the owners? Are there any expiration dates to this sort of preferential tax treatment that we should know about? Things of that nature. Again, property address. Okay, Foreign Investment and Real Estate Property Tax Act, FIRPTA. This was recently added, or has become more prevalent recently in our forms, now in the purchase agreement, because it can have some implications for a buyer who's buying a home from a seller that's a foreign person. Okay, there's a section in the Internal Revenue Code that the buyer of the United States real property interest must be notified in writing and must withhold tax if the transferor or the seller is a foreign person and has no exceptions from FIRPTA. Or excuse me, if no exceptions from FIRPTA withholding apply. Okay, so now we're asking the seller a big question here. The seller represents that the seller is or is not a foreign person, right? Now I know it sounds goofy. This is not a discriminatory thing. It has everything to do with taxes. Now I'll explain to you why in just a minute. Now let me ask you this. Is it fairly common that properties are owned by two people? Perhaps a husband and wife, right? So it's asking, are either one of you a foreign person, right? Either one. Okay. Note, if the above answer is, the buyer may be subject to income tax withholding in connection with the transaction, unless the transaction is covered by an exception, right? In non-exempt transactions, the buyer may be liable for the tax if the buyer fails to withhold. If the above answer is not, the buyer may wish to obtain specific documentation from the seller ensuring the buyer is exempt from the withholding requirements regarding the law. So I'm going to feed this, I'm going to finish reading this and I'll recap it. Due to the complexity and potential risks of failing to comply with FIRPTA, including the buyer's responsibility for withholding the applicable tax, the buyer and seller should, in bold, seek appropriate legal and tax advice regarding FIRPTA compliance, as the respective licensee, the agents, representing or assisting either party will be unable to assure either party whether the transaction is exempt from FIRPTA holding requirements. You can also utilize your title company for help with this as well. So this is timely because a few months ago, Carly ran into this issue on a transaction where we represented the buyer and the seller didn't disclose until after we were into the transaction that his wife, who he had just recently married, was a foreign person who wasn't even in the U.S. right now, which triggered a FIRPTA question for us, right? And he was trying to get our buyer to say, hey, I'm not going to do he wanted the buyer not to do the withholding, right? Because he said, I'm exempt, we don't need to worry about it. And we said, well, absolutely not. We're going to do the withholding, and then we'll just let you work it out afterward. And if you can prove and get the IRS's permission, then you can get your money, right? But it's an important question that needs to be addressed on the front end, because once the buyer closes on that transaction, they officially take on the liability for that tax burden. Because this is the reason this exists, is this is what happened. What would happen? The seller would not disclose this. They'd close on the property and they'd go back home. They're outside the U.S. The U.S. we want to collect our taxes, right? So guess what? They can't get it from that person anymore. It's going to come to the next person, which is going to be the new owner of that property. So it's a huge, huge issue that you need to have clarified and looked into upfront before you close on something like that, because the implications are pretty Pretty huge. Methamphetamine production disclosure. The seller is or is not aware of any meth that's been produced on the property.
So have you ever had anybody check mark that?
No, thankfully. Which would trigger the methamphetamine disclosure, which used to be like a regular form we do, now we don't because it only gets triggered if they answer yes to that. Notice regarding airport zoning regulations. The property may be in or near an airport safety zone with zoning regulations, etc. Notice regarding carbon monoxide detectors. Hey, we need them in certain areas. Cemetery Act. Are we on close to a cemetery? Are you aware of any human remains, burials, or cemeteries located on the property? Yes or no? Sounds like a goofy question, but a lot of older farms, what they used to do when people pass away back in the day. Bury them right there, right? So hey, we need to know about that.
I have a good friend in South Dakota whose mother's buried right outside the back door, and I go, what are you gonna do? They said, I can't take her with them.
Right.
What do you do?
Yeah.
I mean,
It's goofy.
it is.
All unidentified human remains or burials found outside of platted, recorded, or identified cemeteries and in context, which indicate antiquity greater than 50 years, shall be dealt with according to state law. Environmental concerns. To your knowledge, have any of the following previously existed or do they currently exist on the property? So if you bought the property from somebody before and they told you about this, well, then you have knowledge and you have to also, you may not have witnessed it firsthand, but if they told you about it, you have knowledge, now you have to disclose. Animal or pet infestations, asbestos, diseased trees, formaldehyde, hazardous waste substances, lead, mold, soil problems, underground storage tanks. Other, yes or no? Property address. Have you been contacted or received any information from any governmental authority pertaining to possible or actual environmental contamination affecting the property? Kind of a big deal, right? Are you aware if there are currently or previously have been any orders issued on the property by any governmental authority ordering the remediation of a public health nuisance on the property? Hey, you might not have an issue right now, but have you ever had an issue, right? Or do you currently have one? That's what we're asking. Then please clarify. Radon disclosure. The Minnesota Department of Health strongly recommends that all home buyers have an indoor radon test performed prior to purchase or taking occupancy, and recommends having the radon levels mitigated if elevated radon concentrations are found. Elevated radon concentrations can easily be reduced by a qualified, certified, or licensed, if applicable, radon mitigator. Every buyer of any interest in residential real property is notified that the property may present exposure to dangerous levels of indoor radon gas that may place occupants at risk of developing radon-induced lung cancer. Second leading cause of lung cancer is radon, just behind smoking. Radon, a class A human carcinogen, is the, oh, look at that, I got ahead of myself, is the leading cause of lung cancer in non-smokers and the second leading cause overall. The seller of an interest in residential real property is required to provide the buyer with any information on radon test results of the dwelling. I'll use myself as an example. When we bought our house, we had a radon test, right? So now when I go to sell, I need to disclose that we had a radon test way back when and here were the results, right? Well, they'll also know that we've got a mitigation system, okay? Before, sellers did not have to disclose this. Maybe 3-4 years ago, the state law changed and said, hey, any knowledge that you guys have regarding radon, the levels and testing, et cetera, has to be disclosed to buyers.
Do you still test like once a year, even with the radon?
Me, in my personal residence, I don't, just because we don't have a bedroom down there. I'm only down there every so often. But if I had somebody who was living down there, I would probably test it on at least maybe a basis, just to make sure. And I would test it in the wintertime, because that's when your concentrations are likely to be the highest. Radon in real estate. By signing the statement, buyer hereby acknowledges the receipt of the Minnesota Department of Health's publication. There's a radon disclosure. You can get it from the MLS. You can just give it to buyers. Give it to your sellers as well. A seller who fails to disclose the information required under state law and is aware of the material facts pertaining to radon concentrations in the property is liable to the buyer. A buyer who is injured by a violation of this law may bring a civil action and recover damages and receive other equitable relief as determined by the court. Any such action must be commenced within 2 years after the date on which the buyer closed the purchase or transfer of real estate property. It's a little bit of a statute of limitations. Okay, it's got to happen within a couple of years, otherwise you snooze, you lose. Seller representations. The following representations made by the seller regarding their knowledge. Radon tests have or have not occurred on the property. Describe any known radon concentration, mitigation, or remediation. Hey, we've got a mitigation system. We've had one since this date. It was installed in this date, etc. There is or is not a radon mitigation system currently installed on the property. If is, the seller shall disclose if known information regarding that system, etc.
Now, radon mitigation system isn't just a radon alarm, right?
Correct. When we go over drain tile, I'll also show you what that system looks like and how it works. Great question. Property address. Notice other defects, material facts. The following questions are to be answered to the best of the seller's knowledge. They have or have not received a notice regarding any proposed improvement projects from any assessing authority, the cost of which project may be assessed against the property. Street repairs, work on sewer lines, things of that nature. Hey, is the city, the county, anybody come to you and said, hey, we're about ready to make an assessment against this property? The buyer needs to know that. They don't just get surprised and inherit it, right? Other defects or material facts. Are there any other material facts that could adversely affect the use or enjoyment of this property? This is basically kind of a catch-all. Hey, is there anything else this form did not cover which could potentially affect the use or enjoyment? Yeah, actually, every night at midnight, a loud train goes by, right? Could you argue that that would affect somebody's use or enjoyment of the property? You probably want to disclose it. Otherwise, on the day of closing, that night, somebody's probably going to get a phone call.
What if you have a bad neighbor?
Right? Water intrusion and mold growth. Studies have shown that various forms of water intrusion affect many homes. Water intrusion may occur from exterior moisture entering the home and or interior moisture leaving the home. Examples that can cause this: improper flashing around windows and doors. That's a huge one. Improper grading, huge one. Flooding, roof leaks. I would say downspouts that are not connected. Examples of interior moisture sources might be, you got plumbing leaks, condensation, overflow from tubs, sinks, or toilets, firewood stored indoors, indoor sprinkler system goes off. Humidifier, inadequate venting, improper venting, line drying laundry indoors. Houseplants. Houseplants can wreak havoc if you have a jungle in your home. That's going to affect the moisture of your property, right? I'm talking a legal, not an illegal kind of jungle. There's some of those too. In addition to the possible structural damage water intrusion may do to the property, water intrusion may also result in the growth of mold, mildew, or other fungi. Mold growth may also cause structural damage to the property. Therefore, it's important to detect and remediate water intrusion problems. Fungi, or fungi, are present everywhere in our environment, indoors and outdoors. Many molds are beneficial to humans. However, molds have the ability to produce crazy stuff that may have potential to cause serious health problems, particularly in some people. This is basically a little mold disclosure.
So I have a question about that.
Yep, let me finish this paragraph real quick. To complicate matters, mold growth is often difficult to detect as it frequently grows within wall structures. If you have concern about water intrusion or the resulting mold, mildew, fungi growth, you may want to consider having the property inspected for moisture problems before entering into a purchase agreement. Such analysis is particularly advisable if you observe staining or musty odors. Now, this would be an instance in which we talked about in the inspection contingency before, that you might ask for intrusive testing to be able to poke holes in the drywall and do a test for mold or moisture, right? But you would likely have a good reason to do so. You wouldn't just randomly decide you're going to do it. And remember, the buyer does it, they've got to repair the home back to the same state. Yes, ma'am.
So I had an inspector one time tell one of my buyers, there's mold in every house, no matter what people say, because you have mold spores everywhere. So everybody should be checking, yeah.
That there's mold in the home?
Yeah.
Yeah. Well, I would say, guess what? Seller's disclosure are to the best of my knowledge. To the best of my
And if
knowledge.
you're not testing for it, you're not a mold expert. I mean, nobody is. And I know on this particular house, this was a foreclosed home, and there was like a white dust along the sheetrock downstairs. Well, that white dust ended up being like mold spores, is what it was. Not the type that will kill you. However, since there was no circulation going through the house, they just attached themselves to the wall.
So when I lived in Florida, I had a couple.
Oh Lordy, you probably got all kinds of
Well,
potential
yeah.
mold issues down there.
I lived there and I was gone for the summer and I came home and there was mold on my couch, like gross green stuff. And I called somebody and they said it's gonna be $10,000 to take care of it.
Yep.
Oh,
And
Lord
then
have
I
mercy.
called another gal who came out who was actually a mold specialist.
Just bleach it.
And she said, yeah, just clean it all with wipes or something like that. And she tested it, it was all fine.
Good. Yeah. You know, so up in Minnesota, our winters are pretty good when it comes to this potential issue, but our summers can be pretty hot. Well, not quite Florida, but they get hot. If a home sits, this was happening a lot more when we had a lot of vacant foreclosed properties. In the summertime, man, mold would just go to town.
Right.
Especially if there's a water issue as well, it's just going to go to town. So when in doubt, test. When it's being found, usually it's in the basement or it's around windows or in a bathroom that doesn't have proper ventilation.
That's what happened to us when we were in Florida for family reunion.
What's that?
Our bathroom was full of mold.
Oh, really?
Oh, God, you could smell as soon as you walked in.
And usually sometimes you walk into a basement, you kind of just, you can tell.
It takes your breath away.
Yeah, it's damp or it's moist or it's
Yeah.
got some mold.
Yeah.
Line 355, notice regarding predatory offender information. Basically, hey, here's a website that I have to make you aware of. You can go ahead and visit it to see if there are any potential registered sex offenders that live nearby any of the properties you might be interested in. That gets covered in the agency form as well. Property address, additional comments they might want to add. Minnesota state law, material fact disclosure, exceptions. The seller disclosure requirements do not apply to real property that is not residential real property, a gratuitous transfer, a transfer pursuant to a court order, a transfer to a government or governmental agency, transfer by foreclosure or deed in lieu of foreclosure, a transfer to heirs or devisees of the descendant, a transfer from a co-tenant to one or more other co-tenants, a transfer made to a spouse, parent, grandparent, child, grandchild of seller, transfer between spouses, transfer of newly constructed residential real property that has not been inhabited. That's interesting. Could you still have an inspection of a new construction home?
Mhm.
Good. An option to purchase a unit in a common interest community until exercised. A transfer to a person who controls or is controlled by the grantor, as those terms are defined with respect to the declarant. A transfer to a tenant who is in possession of the residential real property, or a transfer of special declarant rights. Basically, if we've got relatives or trusts involved, etc., that might not be required, or if you own the home and you've had somebody living there for a period of time, you sell it to them, they're saying, hey, you don't necessarily need to disclose anything because they've already been living there. They should know, right? Radon Awareness Act. Waiver. The written disclosure required under sections blah, 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 blah may be waived if the seller and the prospective buyer agree in writing. No duty to disclose. There's no duty to disclose the fact that the property is or was occupied by an owner or occupant who is or was suspected to be infected with HIV. Was the site of a suicide, accidental death, natural death, or perceived paranormal activity. Don't have to disclose these things. Is located in a neighborhood containing any adult, family home, community-based residential facility, or nursing home. Hey, we don't have to disclose that stuff. Predatory offenders. There is no duty to disclose information regarding an offender who is required to register under state law, or about whom notification is made under that section. If the seller, in a timely manner, provides a written notice that information about the predator offender registry and persons registered with the registry may be obtained by contacting local law enforcement agency and where the property is located or the Department of Corrections. It's kind of that website disclosure again. When in doubt, disclose. It's always my policy. The provisions in paragraph A and B do not create a duty to disclose any facts described in paragraphs A and B for the property that is not residential property. Inspections. Except as provided in paragraph 2, the seller is not required to disclose information related to the real property if a written report that discloses the information has been prepared by a qualified third party and provided to the prospective buyer. For the purposes of this paragraph, qualified third party means a federal, state, or local governmental agency or any person whom the seller or prospective buyer reasonably believes has the expertise necessary to meet the industry standard of practice for the type of inspection or investigation that has been conducted. So this is an interesting.
Does that mean that if they have an inspection, they don't have to fill this out?
If they provide you the inspection. So you can provide an inspection report in lieu of seller disclosures,
Sure.
so long as the buyer finds the inspector to be satisfactory, right? Meaning that they are okay with the credibility and legitimacy of that inspector. Very rarely do you see this happen. And oh, by the way, it doesn't mean the buyers can't also still have their own inspection. I would always recommend it. Seller shall disclose to the prospective buyer material facts known by seller that contradict any information included in a written report. So if they get an inspection and the inspector missed something that they know about, they still have to disclose it.
Right.
Right. They can't just say, well, the inspector didn't catch it, even though he did. No, it doesn't work that way. Property address. Seller statement. Seller hereby states the facts stated above are basically true to the best of their knowledge, etc., etc. Here's an important part in the last paragraph. Seller is obligated to continue to notify the buyer in writing of any facts that differ from the facts disclosed, here, new or changed, of which the seller is aware that can adversely and significantly affect the buyer's use or enjoyment of the property or any intended use of the property that occur up to the time of closing. To disclose new or changed facts, please use the amendment to disclosure statement. This is a change. What we used to do is have everybody sign off. Then we would wait till we signed off on this to say, hey, did anything change between now and when these disclosures were originally written, right? But what we were failing to do is capture all that time that was pending, right? So hey, if something happens before we close, you still have to disclose it. Just because you're under contract doesn't mean you're free and clear now. If something happens, which gets back to the example I gave earlier about the water. Sellers sign, the buyers sign, and again, if any changes occur, a disclosure amendment would get added to this transaction.
I had to do that because we got water in the basement.
Oh, really?
Mm-hmm.
Here's just a quick example of that radon disclosure. What I do is I typically provide this to both buyers and sellers, and I'll have them sign off on it, or I should say initial next to it, just saying that they got it. We'll very quickly work through arbitration. This is the last one for today. Oh yeah, got a little bit long. If you need to leave, feel free. Arbitration disclosure. Okay, so this gets presented to both sellers and buyers. You have the right to choose whether to have any disputes about disclosure of material facts affecting the use or enjoyment of the property that you're buying or selling decided by binding arbitration or by a court of law. By agreeing to binding arbitration, you give up your right to go to court, in theory. By signing the residential real property arbitration agreement on page 2, you agree to binding arbitration under the residential real property arbitration system, administered by the National Center for Dispute Settlement and endorsed by the Minnesota Association of Realtors. The arbitration agreement is enforceable only if it is signed by all buyers, sellers, and licensees representing buyers and sellers. Everybody has to sign off on this sucker, otherwise it's not enforceable. That means the agents too. So the buyers and sellers could sign off, and one agent could sign off, but if another agent doesn't sign, it's not enforceable. It doesn't mean you can't still use arbitration if people agree to it, but it just means it's not enforceable, right? Let me ask you this. Is this document part of the purchase agreement?
No, it's separate.
Correct. This is not part of the PA. It is a separate agreement. It is a separate form. The arbitration system is a private dispute resolution system offered as an alternative to the court system. It's not a government-sponsored program. They jointly adopt the rules that govern the arbitration system. They're not affiliated. Under the arbitration agreement, you must use the arbitration services of NCDS. All disputes about or relating to disclosure of material facts affecting the use or enjoyment of the property, excluding disputes related to title, are subject to arbitration. This includes claims of fraud, misrepresentation, warranty, and negligence. Nothing in this agreement limits other rights you may have under state law or under private contracts for warranty coverage. An agreement to arbitrate does not prevent a party from contacting the Minnesota Department of Commerce. the state agency that regulates the real estate profession about licensing compliance with state law. Hey, I might take an agent to arbitration. I might win $5,000. And oh, by the way, I can still report you to the Department of Commerce.
So when would you sign this?
You would typically sign this when you're coming to term. If you do sign it, you would sign it, or you would present it at the time of a purchase agreement.
Do you sign them?
Do I? We do. Our client signs it. We typically sign it. Just because I don't ever want to be the reason why they can't arbitrate. You'll find this. You could have a whole good discussion on arbitration, whether or not you think you should or shouldn't do it. But this is presented at the time of writing a purchase agreement because it's property specific. Because it's the buyers. It's a conversation between buyers and sellers related to a specific property. Okay, the administrative fee for the arbitration system varies, depends on the amount of the claim, but often it's less expensive than court filing fees. In some cases, conciliation court is cheaper than arbitration. That's a small claims court. The maximum claim allowed in conciliation court is $15,000. So if you want it to be more than that, if it's potentially more than that, then you want to potentially have arbitration as something you can utilize. In some cases, it is quicker and less expensive to arbitrate disputes than to go to court. But the time to file your claim and pre-hearing discovery rights are limited. The right to appeal an arbitrator's award is very limited compared to the right to appeal a court decision. So this paragraph is a good paragraph in helping people weigh the pros and cons of choosing to go arbitration versus not choosing to go arbitration, right? Or having a court and suing somebody available to them as an option. A request for arbitration must be filed within 24 months of the date of closing on the property, or else the claim cannot be pursued. In some cases of fraud, a court arbiter may extend the 24-month limitation period provided herein. Okay, 2 years is kind of a magical number. It has a lot to do with the statute of limitations in regard to how far back can we go after something, right? A party who wants to arbitrate a dispute files a demand along with the appropriate administrative fee with the NCDS, who then notifies the other party, who may file a response. The NCDS works with the parties to select and appoint an arbiter to hear and decide the dispute. A 3-arbiter panel will be appointed instead of a single arbiter at the request of any party. The party requesting a panel must pay the additional fee. Arbiters have backgrounds in law, real estate, architecture, engineering, construction, or other related fields. Arbitration hearings are usually held at the home site. Parties are notified about the hearing at least 14 days in advance. A party may be represented by a lawyer at the hearing at the party's own expense if he or she gives 5 days notice to the other party and to the NCDS. Each party may present evidence, including documents or testimony by witnesses. The arbiter must make any award within 30 days of the final hearing date. The award must be in writing and may provide any remedy the arbiter considers just and equitable, that is within the scope of the party's agreement. The arbiter does not have to make findings of fact that explain the reason for granting or denying an award. The arbiter may require the party who does not prevail to pay the administrative fee. The arbitration disclosure provides only a general description of the arbitration system and a general overview of the arbitration system rules. If you have questions, call these numbers.
So what this is saying basically is that the buyer has to pay the upfront fee.
Whoever files the claim.
Right. Well, normally it might be the buyer. I would.
Almost always going to be the buyer. But here's the deal, Deb. This could be between seller and their agent too.
Sure.
You know, so it's going to be the.
Yep. Okay.
Disclosure statement continued regarding the arbitration disclosure. Very, very big, very important. This is an optional voluntary agreement. Read the arbitration disclosure on page 1 in full before signing. Okay, it's a big warning to everybody about this. Okay, property located at city, county. Any dispute between the undersigned parties or any of them about or relating to material facts affecting the use or enjoyment of the property, excluding disputes related to title issues, covered in the purchase agreement dated, the date of the purchase agreement, including claims of fraud, misrepresentations, warranty, and negligence, shall be settled by binding arbitration. The NCDS shall be the arbitration service provider. The rules adopted by the NCDS are the Minnesota Association and the Minnesota Association of Realtors shall govern the proceeding. The rules shall govern the proceedings and are those rules in effect at the time of the demand for the arbitration is filed and include the rules specified in the arbitration disclosure on page 1. This agreement shall survive the delivery of the deed or contract for deed in the purchase agreement. This agreement is only enforceable if all buyers, sellers, and agents have agreed to arbitrate, as acknowledged by the signatures below. For purposes of this agreement, the signature of one licensee of a broker shall bind the broker and all licensees of that broker. This is where people would sign or date. Now, if they choose not to sign arbitration, what I will do to show that we went over the form is I would just put a big line through it. I will write declined, and I will have an initial next to it. And if my clients decline, then I don't sign. But if they do sign, I typically will sign. And the other party doesn't have to sign. They can or cannot. I would say it's fairly common for people to sign off on arbitration. But every once in a while, some people choose not to. Okay. Any questions on that one?
No.
Very good. I appreciate your time.
Thanks, Zach.
Yeah. We will talk about drain tile if you have time.
Yeah, I do.
Okay, we'll talk about drain tile and radon real quick.